So, part two. Thank you very much. And both Dr. Blitz and the prior speaker, you'll probably hear some terms that are familiar. Okay, we've already gone through basically, we've gone through enough of what I do. Okay, how come, oh, this one, there we go. Okay, now here we are into our practice tips or how to stay off the radar.
You're on, you ready?
Okay, I'm rolling. This is a Nevada revised statute, that little number. This is Medicaid fraud. The plan, with respect to the plan, that's Medicaid. A person with the intent to defraud makes or causes to be made a claim knowing it to be false in whole or part by commission or omission. All right, so the crime of Medicaid fraud is a specific intent crime. It's not a general knowledge crime, and it's not really a neglect. It's even more, the burden's a little bit higher on specific intent than it is on willful and wanton conduct. Okay, so it's a very specific intent crime. But don't, we have a tactic where we do pre-charging negotiations. We'll sit down with the purported defendant and go, and say, hey, you're about to get charged, bring your lawyer in, let's see what's really happening. And so we'll have pre-charging negotiations, and we usually try to strike something that's palpable for both sides. But don't walk into the office and say, yeah, he wanted to cheat his partners. He really didn't mean to cheat the Medicaid plan. That won't fly. There are backup statutes that I could use instead of just the specific intent of in Medicaid fraud. And what's some of the importance of this, we'll get into this later, a little bit more later on, is how you're charged and how much of a public record as a result of those charges may affect the future, well, seriously affect the future of your practice. Crimes that are involved with the provision of healthcare or healthcare services or goods usually end up with a mandatory exclusion. Starting at 5 years, could be for life. Pre-charging negotiations allow us to see what really happened by the practice, and if it's really worthy of a healthcare fraud type charge or maybe some other type of charge. Some other type of charge will allow you to maybe survive the federal exclusion process and the state's exclusion process. It would probably allow you to maintain your license. Let's say if you are excluded and you maintain your license, you have to work in private clinics primarily or selling cars. Let's see, and it also working in advance with the prosecutors or with the attorneys allows you to avoid a public record. So unlike what happened in California around 2002 to 2004, there are a couple of cardiologists that were brought up for performing unnecessary heart surgeries. That probably would have never made the papers if they would have worked with the prosecutors and gotten their side of the story out. And there wouldn't have been a long series of publicly filed charging documents. There would not be grand jury testimony and transcripts. There would not be preliminary hearing testimony and transcripts. There would not be other pretrial litigation, motions, and evidence floating around. All that's very important for everybody's future actions. And if the federal government, Federal Office of Inspector General, is expected to take exclusion action, it's a parallel proceeding, they need evidence. And what they usually do is they go, Mark, I want a copy of the grand jury transcripts. Mark, I want the transcripts from the preliminary hearing. You might have, people might have seen, I can't say you in this crowd, you guys are just too good. Defendants might have seen the light and decided to take the benefit of a bargain, but once that public record is made, it can't be made private again. So other agencies and other entities, medical boards, other overseers, other regulatory bodies, they can get access to those public records and those transcripts. So you do want to try and get ahead of the train. Now, I mentioned earlier the Civil False Claims Act. This is not a specific intent crime. Keep your friends close and keep your enemies closer. You never know who you're going to offend. Usually they're started by a secret witness. Usually they're an employee within the practice because they have to have, hopefully, they're supposed to have firsthand knowledge, and they walk in and they file a formal lawsuit naming the government as a plaintiff. It's called the old Lincoln Law, and prior to that, it's common law. When Lincoln was fighting the Civil War, when kings were out fighting, during the Civil War, we bought a lot of horses, opened up the railroad cars, and there were mules. Well, Lincoln didn't have the time to actually sue the provider, so other people sued in the name of the government. Secret witnesses came in. They were trying to run this lawsuit in the name of the government. Everything worked out. The government would either get horses or or recoup some funds. Now, flash forward, that witness who sues in the name of the government stays secret. They file the lawsuit. The lawsuit stays sealed. The due diligence investigation is run by the government. It might take 3 or 4 years to finish this. If there's a resolution at the end, of course, we all know that the relator, the whistleblower, that secret witness gets a percentage of the award. So it's evolved to something beyond just being a good citizen. It's now a moneymaker. What is 15 to 30% of, $800 million? So we have serial whistleblowers who will work different agencies, and we have the one-off whistleblowers, and they are in it for the betterment of the industry. Okay, and that's on here on the False Claims Act, the scienter or the mental intent, actual knowledge, deliberate ignorance, reckless disregard. You do not need specific intent. We've already talked about materiality, and materiality right now in healthcare fraud is a huge term. There's a recent case came down from the Supreme Court called Escobar on materiality for the filing of false claims. And did it influence a decision of a provider to pay? Anti-kickback statutes. That's soliciting or receiving remuneration, directly or indirectly, overtly, covertly, cash, in exchange for a referral to furnish a service. Okay, those are the basic elements of an anti-kickback violation. So if you're soliciting or receiving remuneration, if you're working in cahoots with somebody else to receive a little bit of extra benefit, or to get here's the one I was looking for. And we might have had something similar to a Stark Law violation during the week. I understand that you all played kind of like a poker run the other night?
Yes.
Yes. You had an unusual amount of royal flushes at the end?
Yes. Yes. We did, but we resolved that problem too.
Okay,
Yes.
So you don't think someone walked up and made it, hey, you give me a couple of jacks.
Oh, no, I know
I'll
they
give you a
did.
couple. Okay.
Oh, I know they
All
did.
right.
Oh,
All
I
right.
know they did.
Okay. Yeah.
There was
Okay.
a skim going on. There's no question.
Okay, so prior to you all accepting the awards, there was a kind of like a little, as they kind of call them, a come to Jesus meeting, a pre-accusation session, and everything got leveled out. Okay.
That is correct. And everyone complied.
Now, I've never
they all
had to
pointed at each other and
I've never
said
had
they
to
cheated.
flip a coin and say, I'm going to charge you, I'm not going to charge you. But I understand that that there are certain ways of doing this. I will tell you one thing. I have separated a lot of clients from their lawyers. And I have separated a lot of lawyers from their clients. I had a doctor that we worked out a decent pre-charging investigation, and it was a mid-level criminal charge, and he started to balk on the ability to pay. And I said, why don't you have him auction off the letter written by then Senator Kennedy, John F. Kennedy, auction that off and give me the proceeds. And he came back and he goes, how do you know about that? That's my job, all right? I have had someone walk into the room, a case that started out with a mild offer of $38,000. Subsequent offer about a year and a half later for about 500,000, no, 350,000. And in that, when I received the 350,000 offer on June, I think it was like June 15th, I said, on May 27th, you had a board meeting at the clinic. Your clients had a board meeting at the clinic. And so said, don't worry, the lawyers have this worked out for $500,000. This is going to go away. $1.37 million later, and 2 criminal charges, it went away. And they said, how did you know that? I go, that is my job. All right. Okay, here we're at Medicaid Services Manual. Now, a Medicaid Service Manual, every state has one, all their Medicaid organizations have them. They have a different definition of fraud, an intentional deception, and they also have what's called overpayment and underpayments, and they will have overpayment, underpayments, and improper payments. There's a big laundry list on what are improper payments. We can, this comes into play. The Medicaid Service Manual is a regulatory item. It also, in Nevada and many other states, is promulgated in a manner that is the same promulgation or enactment as a law. So when you violate the Medicaid Service Manual, which you all are supposed to understand and have memorized and probably keep a copy under your pillow, you're actually violating a law. We can make the connection to do that, and we have. Investigative triggers. Now that's a pretty long laundry list. When we talked about this one-off switching of codes, there are some things that would change that. Is there consistent or routine one-off upcoding? Are you an outlier? Are you higher than most of your peers? And not just of your physicians, of that particular type of physician and maybe in that particular area. Excessive use of certain billing codes, routine use of the highest. Yeah, a lot of the 2-digit modifiers come in there. Rare services that keep popping up. Things that are designed to avoid these automatic computer edits. That's trend. As soon as a computer edit will pick up an error and they start to send notices out, you're using the wrong code, you continue to do that, we're going to have the state of Nevada Medicaid will say continue to do that, we expect a recoupment. Then we see this unique code, not the code that should be coming up, but then another unique code that slips through the edit. They actually have people who test codes. They'll make several, half dozen of them, and 3 of them get rejected, 3 of them don't. So they're going to then focus on these new 3 codes they never used before. Hey, they're not getting picked up. Why do you do this for 20, 30 bucks additional crack? I don't know. Because the penalties on the civil side are $5,500 to $11,000 per false claim. And on the criminal side, even on the state civil side and the criminal side, it's 3 times the amount of the false claim, 3 times the amount of my cost to figure that out, and interest. A couple other things are in there. So, oh yeah, that too. 1 to 4, only 1 to 4. It's a low-level misdemeanor. Most everybody walks, and that's probably fair. The local and state jails are nothing that they usually show you on TV. So almost everybody walks. We had a physician not too long ago that I was at the baseline of, we had a hepatitis outbreak here in Nevada, and the Board of Health didn't know what to do when they thought they had something on that, and the state regulatory body didn't know what to do. They came and visited me because they know that I had shut down something else in a similar situation a few years earlier. So this hepatitis outbreak I got first crack at, and I helped orchestrate or put together some of the investigative prosecution themes for both the local and the federal governments. At that time, I was still maintaining my assistant U.S. attorney's, special assistant U.S. attorney status, and I co-prosecuted in the federal system on that. Just on the fraud side, the state and local system took the criminal neglect of patients and the acting without lawful authority, and then neglect of duty charges. That was the issue. That's the one, neglect of duty. The local prosecutors never even heard of that count. In a newspaper article, the reporter goes, well, that's unusual. There's a person in the state attorney general's office who's been charging neglect of duty for over 10 years. That's me. And so anyways, that physician was convicted on both the patient harm side and on the fraud side. There wasn't too much we wanted to do to that person. He was already doing time, and I think about 3 months ago he died in prison. So frequent billing of rare services. Okay, so now these big all bolded words: time, complexity, proximity, and relationships. Time, not just your time that you're with the patient in doing a procedure or in the office. There are lots of other times going on. Anesthesia is timed independently. Patient prep, patient waiting rooms, recuperation rooms, prep rooms, everything is usually running on a clock. So if you're going to routinely bill based on time, let's say certain procedures will come with 7 or 8 automatic units of time units. They pay you so much per time unit, and a time unit may be 15 to 30 minutes. And if you go up, but they'll give you, let's say, on 30 minutes, let's say they give you 4. So that's 2 hours. 2 hours worth of money for that procedure right off the bat. All right? So you get 4 units just for that procedure. Then after, you don't have to go the full 2 hours, but let's say after 30 minutes, you can start to get other units billing towards you. So if all the time units are 1, 2, 3 minutes into something out of the standard block, out of that first 30, and just kind of creep into the next unit consistently, we may have a problem, okay? And then you compare that to the other times, the sign-in times, the sign-out times, and all that other things. We may have a problem, all right? Complexity. Why are certain things always billed at the most complex code? Well, we've had practices that specialize in complex pregnancies. That's a given. That's a taken. Others shouldn't and don't do procedures on a routine basis that are very complex. So we'll look at that. Well, we have experts here. Blitz only takes it sounds like he only takes the toughest, most complex cases. I wouldn't look at Blitz the same way I might look at somebody else, but
Thank you.
In fact, the blitzes maybe in my circle of who do I go to, who do I talk with. Proximity. How close are you to your practice? How close are you to what's happening in that room? There's incident to billings. You have to be somewhere within the physical proximity to be responsible and to have people bill under your billing level. And it's different in different jurisdictions. We're a very rural state. We have 2 pockets of people, and you can go hundreds of miles without even seeing a car, but we can supervise over the phone. We have those relationships going on. But what is your physical proximity? You shouldn't be on the golf course. You shouldn't be out on the West Coast at Carlsbad or Oceanside. You should be where you're supposed to be. You should, and we have access to plane records, of course, passports and things of that nature. We'll get your physical proximity, your relationships. Hell hath no fury, like the scorned spouse. Thank you very much, dear. Really, we get a lot of cases that walk through the door because of screwed up relationships or screwed over relationships. Is that appropriate presentation speak? Uh-huh. Okay. Yes.
We say far worse.
Okay. I'll try not to. All right. Your relationships with your staff cannot necessarily get you out of trouble, but they probably avoid a lot of, let's call it vindictive issues. There are a lot of vindictive issues that we're stuck trying to correct, or trying to overlook, or trying to walk through. And I actually get a little bit upset with these vindictive issues because I'm wasting resources. And for every vindictive issue I'm chasing down that has no merit, that I'm obligated to look at, the bad physicians are getting further down the road. They're getting deeper into the state pockets, and it's not good for anyone. So anyway, but relationships, bad partnership mergers, bad partnership breakups, and where there's a lot of mergers and breakups right now. This is a crunch time in the industry. We have to be able to look through that and see what's really fraud. Okay, these are some of the standards. Time and dates of service. Nobody with 4 kids is going to be coming into a clinic at three separate times a week. So don't spread it out. You know, I mean, that's kind of a given. Things like that. Who actually provides the service? This may be something you can check because a lot of us have operate under entities that are accepted and approved by their insurance companies. And so everybody who works in that entity, the claim goes in under the entity's numbers. Well, lots of providers want individual applications and approval processes for those people who are assigned in those entities. So if you got Dr. Smith working in the ABC clinic and everything's being billed under the ABC provider numbers, and Smith is not on the listed pre-approved list of physicians, that's either a mistake, or if it's intentional, it's something other than a mistake. It's not a mistake. Some of the best defense attorneys in here have contributed over the years, volunteers to produce. They want to get in front of the train a little. Where are we at, 14 to 17? They want to make sure that their clients don't obstruct justice. They want to avoid conflicts of interest with the client's employees. So they end up with multiple attorneys for the same practice group. It gets pretty ugly because they can't get ahead of the train and try that sit-down issue. There is copy, date, stamp, one of the best things, and I heard it, was a hospital policy. Look at the hospital policy for consent. All of your practices should probably have some type of a policy or procedures manual. If you don't, get one. Try and adhere to it. Review it. You all have board meetings or management meetings occasionally. I'd say once a year, at least have your minutes show that you reviewed it. Is there any weak points? Providers have been liable for the acts of their employees, even for the false claims. You're liable for the oversight and supervision of those claims, even if you have a separate billing department. Many state statutes and parts of the federal statutes have that built into them, the liability of the owner or the manager of the billing department. So I would recommend a good policy procedures manual. I'd recommend that it be reviewed by somebody else in the industry who's, I'm not big on lawyers, but somebody who can maybe help out and make sure here's a problem. I recommend that it's germane to your area of practice, and I recommend that as trends change in your billings and maybe your reimbursements, because not too many people do a very important step. When remittance advices come in, nobody really checks to see if the money we got listed on that remittance advice really accurately aligns up with what we claimed. So that's a second check. And if someone doesn't know, wow, we really had a good month or a good quarter, and they don't look to see, well, we normally don't use this code. Why are we getting all this money? This money's higher than off of these patients. And you say, we've had a keystroke error or something. We had it in the program and we're routinely using the wrong code. You can catch that on the remittance advices. If you don't square up the money you've brought in to make sure it was not just properly received, but aligns to what should have been properly billed, we're building up an issue of, you missed this warning sign, you missed that warning sign. Throughout your practice, you've got 6 or 7 warning signs. I can't cut you much of a break. You know, you've just been out there too long, too wild. It's time. You're going to get reined in a bit. I'm out of time. I'm on my last slide, and I didn't put that skull and crossbones on there just for this. That's, people know that all around the country.
Come sit down with me.
Uh-oh, I'm in trouble.
So